Good afternoon. This is Dr. Tim Cote with our second lecture in the series, U.S. Food and Drug Law. And today we're going to talk about a historical background. A lot of what we'll talk about today is the Federal Food, Drug, and Cosmetic Act of 1938, which is going back quite a ways. There's been a lot of modifications to it since then, and there was a lot of ramp up to it as well. So let's start way back in drug regulation to the Code of Hammurabi. The Romans and the Greeks and the Chinese and Indian, all cultures have always had some form of regulation of foods and drugs and cosmetics throughout, going all the way back to antiquity. In Rome, there were clear injunctions against the watering of wines. It was punishable by condemnation to the mines. There were food inspectors in 13th century England. In fact, there's a neat story about how a baker's dozen, which is 13, came to be because the laws regulating baked goods and the net weight of baked goods had such punitive penalties that bakers would regularly add an additional one so that they couldn't possibly be underweight and violate that law. That's where baker's dozen came from. Chocolate, tea, coffee, and sugar came on the scene with the great age of discovery of European expansion into India and China and the Americas, and those substances were often found to be violative with dilution of coffee with chicory, for example. So it was trickier, a lot trickier to regulate those products. The American colonies started off and followed pretty much the British legacy of the regulations of food and drugs. In 1820, Ackham, working in a German who was working in London, published a long litany of adulterations. This was when the first time that chemical adulteration had came on the scene. 1855, Hassel published those adulterants in Lancet and received the support of the medical community by doing so. 1860, the English Parliament wrote the first general food law for the whole country, the whole region of Britain under its jurisdiction at the time. And that was later extended to drugs. So you'll see that there is this constant theme of foods and drugs being treated by one and the same because they share the possibility of either being adulterated, and you'll hear that word a lot in this lecture, or misbranded, mislabeled. That applies to both foods and drugs, although naturally these are very different specimens. And so that's the reason why the Food and Drug Administration has come about to be a single unitary agency. In the U.S., most regulation was local. We have this long history of deferring to localities, deferring to the states, and even still, most food inspection activities in the United States that occur are local food inspection activities. Many states do have activities that would regulate drugs as well. They have a drug component to their own local FDA, their own local version of the national FDA. However, they have very little power, and as we already mentioned in the previous lecture, preemption will usually overrule them. In 1850, Lamel Shattuck, after whom some components of the Harvard School of Public Health, where I went, ascribed a decrease in life expectancy in Boston and in New York City from 28 years to 21 years. He's a demographer, one of the early demographers, to adulterated foods. And this was a time in which the sanitary movement, the very beginnings of the public health movement in America was growing up. The concept being, let's make things clean and people will be healthier. The cleanliness is next to godliness, and that even this preceded the germ theory of disease. So we didn't necessarily know that germs were the cause of disease, but there was this notion that if we could just make everything clean and nice, then people would be healthier. And it's not bad advice. the state of my kitchen at home notwithstanding. So at any rate, in 1883, Harvey Wiley became the USDA, the U.S. Department of Agriculture's chief chemist. So the FDA had its origins in the USDA, the United States Department of Agriculture. Remember, this is an agrarian country, a country with agrarian roots, anyways. And it's natural that food, which could be, agriculture, which can be defined as the process by which people make money from growing food, should be the first ones to be charged with its regulation. And so Harvey Wilson became the USDA chief chemist, and that position later on became the position of the FDA commissioner. So that's the origins of the FDA are within the USDA. Industry called for regulations. So in this case, back in the late 1800s, it was industry itself which was becoming increasingly concentrated into particular places, both food industry and drug industry, that was calling for regulations because industry needed a regulation to push out the unscrupulous manufacturers, purveyors, mongers of patent medicines and drugs. So they were the call for regulation had its initiative within industry, which validates my point I made in the earlier lecture that industry could not exist without good regulation. From 1880 until 1906, there were more than 100 bills that were passed that were introduced into Congress. Only one of them passed in 1906. Only one of them passed over that period, and that was in 1902. The Biologics Controls Act arose from a tragedy, and you're going to hear this theme repeated again and again and again. Drug regulation comes because people die. Okay? They get sick and they die, and there's an uproar, and then in this context of this thing called democracy, the people demand that their elected leaders do something about this. So here's your first tragedy for today. In 1901, there was a contaminated smallpox vaccine that caused tetanus in Camden, New Jersey. There was an outbreak of tetanus, and likewise in it was two tragedies. Also, the diphtheria antitoxin caused tetanus in St. Louis, Missouri. So the people demanded something. So one of the very first, the first laws of that century occurred in response to that tragedy. The 1902 Act was also notable because it was the first act to require pre-market approval of any drug, and this required batching, that the batches would be shown to be safe and effective, I believe, in the 1902 Act, the Biologics Control Act. But the 1902 Act and the 1906 Act that I'm about to mention were both superseded by the 1938 Act, the Food, Drug, and Cosmetic Act, which has retained the same general framework of drug regulation since that time. But in 1906, the first comprehensive approach to this business of regulating food and drugs was the Pure Food and Drugs Act. Dr. Willey, along with the muckrakers, this was a period of time at which there was a considerable self-examination of American society. Upton Sinclair wrote a book called The Jungle, which may be one of the most influential books upon public health in American history. The Jungle described horrific conditions. I read it once when I was in my 20s, and I commend it to any of you. Upton Sinclair's The Jungle describes terrible, terrible situations in the meat packing industry. It makes a call for a socialized approach to American governance that never really took on, and that was Sinclair's truest hope, but he had incredible impact upon food and drug regulation, and particularly meat drug regulation. So in 1906, it also contemporaneously signed into action the Meat Inspection Act, which allocated USDA to inspect meats. And much meat regulation centers upon the activities of meat inspectors. It's a little bit outside of the scope of this course, but you should know that meats are generally regulated by USDA, and foods are generally regulated by FDA. There is some confusion in places where those overlap with regards to whole eggs, shelled eggs, or processed eggs. For example, and then the business of meat is confusing because if there's more than 3%, I believe it is, of meat, then it's a USDA product, and less than 3%, it's an FDA product. So it literally depends on a pepperoni pizza, how many slices of pepperoni there are, as to which set of rules follow the thing. Also, at least for a period of time, open-faced sandwich was considered different from if you put the piece of bread on top, it becomes a sandwich, and then it's regulated by FDA. Open-faced would be regulated by USDA. So some of these rules can be extremely confusing, but in broad generalities, USDA regulates meat, fish, and poultry, and FDA regulates practically everything else. Okay, moving on. So the 1906 Food, Drug, and Pure Foods and Drugs Act was brought into formality this notion of drug or food adulteration. And drugs were defined as all medicines in the USP, the U.S. Pharmacopoeia. So there is this reliance in the definition of drugs upon compendia that have been established by professional societies antecedent to the introduction of these new codifications, these new laws. So a drug was described as adulterated if it failed to meet the USP standards in strength, quality, or purity, or failed to meet its own labeled strength or purity. I'll leave the definition of food adulteration for your reading there in the text. The committee established included Dr. Wiley to enforce the act. There was some controversy that came up pretty early with a court case that I think you should read about called U.S. versus Johnson in cancerine tablets. They were offered as part of Dr. Johnson's mild combination for the treatment of cancer. And it was decided that an unproven therapeutic claim did not represent misbranding. So with the 1906 Act, there was no requirement for the demonstration of efficacy. And in fact, even the FD&C in 1938 did not include in its original genesis a requirement that drugs be efficacious. That didn't come until 1962. You'll hear about that shortly. The 1921 Shirley Amendment expanded misbranding to include false curative treatments, but it put the burden of proof on showing that it was a false curative treatment upon the agency itself. And this is another theme that goes through the history of the FDA. If you give them a lot of responsibilities, but don't give them the funding or the people to enact those mandates, then you're not making a law that works, that's enforceable. The 1906 law had nothing on medical devices or dangerous cosmetics. And multiple disasters occurred throughout the 20s and 30s. There was this depilatory called Coremulu cream, if I'm not, I hope I'm pronouncing that right. It contained thallium acetate, and there were slenderizing compounds, probably amphetamines, with powerful unregulated chemicals, because obesity was not thought to be a disease back in those days. We know for sure it is now. Radiothor was water that contained radium, and it was accurately labeled, and it was killing people, but it made no false therapeutic claims. So again, there was no way to enforce this because it didn't have the legal bearing. There wasn't sufficient basis for FDA or USDA's actions on the basis of the law that was existing. There just wasn't enough power. In 1933, the Bureau became the Food and Drug Administration. That's when it was taken out of USDA and became its own thing in 1933. If you remember back to American politics in 1933, that was the Great Depression, and there was this notion called the New Deal, introduced by Franklin Delano Roosevelt, was the president at the time. This was just before the the Second World War, he was probably one of our strongest presidents in the modern era, and he established Social Security, Medicare, Medicaid. Just an incredible reinvention of government occurred under FDA's rules. People loved him or they hated him. He was in for more than 3 terms, elected 4 times to office. That was when they decided that you could only be elected twice because he was too powerful for Congress. And so there was a lot of tumult and change and expansion of government in those periods, which actually brought us out of the Great Depression. So the new concept of regulations issued by agency, the Congress passes a statute, but this was a change in that the Congress would pass a statute which defined that the agency could pass regulation. It gave it enabling legislation saying, okay, agency, you are enabled to pass regulations on this particular product, and those regulations will have the same force of law as if Congress itself had passed the law. Okay? So they do have the force of law. There are several derivative sources of the extension of government in the control of drugs that you need to know about. So there's the Constitution, which we talked about last night. The Constitution enables the passage of statutes by Congress and has to be signed off by the president or vetoed and overridden by that veto having been overridden. The statutes can often state, okay, agency, you are entitled to pass regulations. Okay, so those regulations can come forward, and finally, the agency itself can issue things called guidances, which those guidances do not have the force of law, but they reflect, quote, the agency's thinking. And you darn well better know what the agency is thinking in order to be able to get what you want done in drug development. So those are a descending series of derivative expressions of governmental power on drug regulation. All right, continuing. So in 1933, there's this new concept of regulation sparked a 5-year debate about what the overhaul should be. And again, what prompted new system of drug regulation? It was a tragedy, and this was one of the most famous ones. There was a drug called Elixir of sulfanilamide. It was a preparation of the new sulfa drugs, and it had been tested for flavor, but they didn't do any pre-marketing testing. And this Elixir sulfanilamide contained the agent diethyl glycol, which polyethylene glycol, for those of you who remember, is also the common antifreeze that we put in our cars. It causes a terrible, terrible reaction with free radicals that attack the liver. You can have hepatic failure. It's just horrible. 100 people died from this thing, okay? And the only legal basis that the agency had, because it hadn't specifically been adulterated, the only legal basis for withdrawing this from the market that they had at the time was on the basis of a technicality, because it was labeled as elixir, and the definition of an elixir is a product which contains ethanol as a solvent. And because elixir sulfanilamide didn't have ethanol in it, that's the way they were able to legally remove this from the market. So in spite of the fact that it was a disaster, there was a safety escape hatch from which the government was able to shut this thing down, and they recognized that something more needed to be done. So it was only a technical violation. The Food, Drug, and Cosmetic Act was approved in 1938, and it has remained the basis of most food and drug regulation. So we're going to go over that. There are 9 chapters to the thing. The first one is the title. The second one is the definitions. Chapter 3 sets forth prohibited acts and penalties, and searches and seizures. And it says what's prohibited is adulteration and misbranding. It established restraining by injunction as a legal mechanism for moving forward to restrain the distribution from interstate commerce. Remember, we're not talking about intrastate, but interstate Commerce, and it provides an opportunity to present countervailing views to the agency before the agency reports a case to the U.S. Attorney, because the U.S. Attorney at the Department of Justice, again, is the only part of the government that can bring criminal charges against violators of the Food, Drug, and Cosmetic Act. Chapter 4 talks mostly about foods. It establishes standards for the identity, the quality, and the fill of particular packages. So the Food, Drug, and Cosmetic Act also concerns economic adulteration and economic mislabeling. It defined adulterated foods as something that contains, quote, a poisonous or deleterious substance, or, quote, filthy, putrid, or decomposed substances, or something that was prepared under unsanitary conditions. So if the product itself can't be shown to be violative, the product there's nothing wrong with it specifically, but it was prepared under unsanitary conditions. This harkens back to the jungle. Okay, if you read the jungle, you'll see that many of these products were prepared under unsanitary conditions, but then you couldn't really discern from the product itself what the conditions of preparation were. Food is also adulterated if it's missing a valuable constituent, or if a substance is added to make it appear to be of greater value. And the most common of this is the addition of water to increase the weight of something. It's also misbranded if it's labeled in a false or misleading manner. So Chapter 4, mostly about foods. Chapter 5, same themes. Adulteration and misbranding apply to drugs and medical devices. It was adulterated if it was found to be unsafe or unsanitary. Also, if adulterated, if it falls below standards from the compendia of strength and purity. It was misbranded if the label is false or misleading, or fails to identify all the active ingredients, or it doesn't contain adequate warnings, or if it's just generally dangerous to the health and use. So it also defined that new drugs need to have new drugs. I'm not talking about the old drugs. It made a definition between new drugs and old drugs. So when the Food, Drug, and Cosmetic Act came into being, this concept of new drugs was established. Anything previous was considered an old drug, but new drugs needed to have an application filed with the Food and Drug Administration. Chapter 6 talks about misbranding and adulteration of cosmetics, and I'll let you all read that. Chapter 7 talks about specific administrative provisions, about issuing federal regulations, how the agency shall issue those regulations, what are the rulemaking procedures. And I think I spoke to that earlier in the last lecture, that when the FDA says, okay, here are the new rules, first it comes out with a notice of proposed rulemaking, then it takes in a bunch of comments, then it comes out with a final rule which specifies all the comments that it received, reviews them, and gives answers as to why this comment was accepted and how things would change or wasn't, and so on. The Chapter 7 also spells out the authority and limits of the establishment of inspections, FDA inspections becoming one of the more important techniques, and we'll have a whole lecture, I think, on the inspection process for the assurance of drug safety and of a good drug supply. Chapter 7 also affords FDA the authority to take samples, to test those samples, to review records of interstate shipment. Those are all parts of the inspection process. To enter and to inspect and to publish reports on formal actions. Chapter 8 is all about importing and exporting, what the FDA can and cannot do. It allows FDA to seize and destroy products which come into this country. There is a notion of xenophobia in American society, and this may have been an expression of it, but it was also an expression of a will of a people to be able to control the material that are coming into its borders. Seize and destroy them. Items for export, interestingly enough, are exempt from many of the adulteration and misbranding provisions. So there was that concession to industry to allow it to export products at a level that was not necessarily the same. However, unapproved new drugs cannot be exported. Chapter 9 repealed the 1906 law. So anything you might read about the 1906 law at this point is moot. But the 1938 law is what forms the basic structure and framework of food and drug regulation in the United States. It has had many, many amendments, and we're going to go over those. And the chapter, a reading chapter, does that as well. So in 1941, there was a requirement for batch certification of insulin, and then other products for antibiotics and several others also were required to have batch certification. Remember, this was World War II. So remember, drug regulation is reflecting, the contemporary history of the time. In 1982, it decided to drop these because those particular drugs could be regulated the same as other new drugs. In 1948, the courts decided that the Food, Drug, and Cosmetic Act didn't reach products after they had arrived in interstate shipments. So remember I said that FDA only has authority over interstate commerce. So the argument was made, but after it's arrived, then the commerce is intrastate, and the courts decided it was intrastate. So therefore, Congress went back. So this is the play of the balance of powers between the legislative and the judiciary system. Congress goes back, writes new laws that straighten all that out and say, no, okay, if it was shipped, it's still part of interstate commerce. And so that extended the Food, Drug, and Cosmetic Authority to products after they had landed in a new state. 1951 was the Durham-Humphrey Amendment. This was the first definition of prescription drugs, and it included habit-forming drugs. So drug abuse is starting to creep into American society, and you're going to see more of this in the 60s. Hello. Those in the 1951 amendment identified those dangerous drugs that needed to have a prescription. The whole notion of prescription, and in this provision was used for many, many years until the formation of the DEA, the Drug Enforcement Administration, which is a part of the Department of Justice, not a part of FDA anymore. So controlled substances are in large part now regulated and controlled through the DEA, which started in the 60s, late 60s. 1952, the courts questioned inspection and many of the provisions of inspection, and Congress reestablished it. So again, there's this interplay of power between the branches of U.S. government, which made the first lecture a little more relevant than you might have thought when you heard it or when I said it, to tell you the truth. You can see that, so Congress, the courts looked at the law that Congress had enacted, said, hey, no, there's a hole with this, it is not constitutional, and the Congress responded by crafting another law which answered the concerns of the courts and continued to advance the intent of Congress to regulate these products, in this case over inspection. In 1954 and 1958, the chemical contamination of foods was becoming a big issue. Congress went forward and set tolerances. Subsequently, a lot of this authority was transferred to the Environmental Protection Agency, or EPA, again, outside of Health and Human Services. But FDA retained some of the authority over certain pesticides. Also in 1958, the Food Additives Amendment Act defined a food additive as any substance intended or reasonably expected to become a food component or to affect a food's characteristics that is, quote, not generally recognized as qualified by experts as safe. So GRAS, generally recognized as safe, is one component, and these others were food additives that were not generally recognized as safe. The 1958 law afforded that an additive is unsafe unless FDA's reviewed data that shows it's safe. So the default became, if you're going to add something to food and it's not generally recognized as safe, it's unsafe, and you're not allowed to do that, and then it's an adulterant. So it also contained an anti-cancer provision, which became fairly important in food and drug regulation, called the Delaney Clause. Now, the Delaney Clause in the 1958 law prohibits the approval of a food additive, quote, found to induce cancer in man or animals, unquote. That became a problem in two particular instances in which Congress had to get into the details of the thing and make special exemptions from the Delaney Clause. The first was DES, diethylstilbestrol, which is known to cause endometrial cancer and other cancers, was commonly used in the management of of meat animals. So such hormonal manipulations had become integral to agriculture. The practice was and continues to be a decrease in managing those DES levels in those animals to trace levels before they were consumed, and yet they still could be detected, and so were violative of the Delaney Clause. Congress got in and made a special exemption for diethylstilbestrol. And a second was in 1977, saccharin, which is a common additive for sweetening things. It's a non-sugar sweetener. Was found in very high doses to cause cancer in rats and mice, and yet it met the Delaney Clause because it could cause cancer in animals. And so Congress got in once again and made a special exemption for saccharin in subsequent law. It required saccharin to be labeled, and then in the year 2000 it changed that too and said, oh no, saccharin doesn't have to be on the food label as well. In 1960, the Color Additives Amendment of the Food, Drug, and Cosmetic Act specified what a color additive is and said that, like other additives, it is unsafe unless specifically approved. And here's a big one for us here at KGI. The 1962 Senator Estes Kefauver, he was investigating price fixing in the drug industry, and there was a public health tragedy that occurred about the same time. So it was a confluence of sort of a perfect storm of activity in the regulation of drugs. Thalidomide was found to cause birth defects. This was about the time that I was I was born. So there was a very heroic reviewer at the Food and Drug Administration at the time, who was recently honored just this last year, and who had received a Medal of Honor from President Kennedy for her actions in reviewing safety and keeping thalidomide out of the United States. But it caused this disease called, this condition called fecomelia, in which the limbs of babies born who had been exposed to this early in development did not grow, and so you had these little babies with stumps for arms or stumps for legs, and so it's a fairly significant impact on Americans, because this pill was given to prevent in the treatment of hyperemesis gravidarum, meaning when women first get pregnant and they puke their guts out. This was an antiemetic. It prevented them from puking. So it was exactly the people who were most vulnerable to having this teratogenic effect, this effect on birth defects. But at any rate, it had been prevented from coming here, and there was a renewed interest in examining the way that we regulate drugs. And Senator Kefauver, in what I consider to be the most important amendment to the Food, Drug, and Cosmetic Act, recognized that we didn't have any requirement that for a drug to be licensed, it had to work. Can you believe that? Okay, so we didn't have any requirement that the thing was safe and effective. So this amendment coded into law that there must be substantial evidence of efficacy, quote, consisting of adequate and well-controlled investigations, including clinical investigations. So it requires that you got to test it in people and make sure that it works in people by experts qualified by scientific training and experience to evaluate the effectiveness of the drug involved. So, in order to get a new drug and to be able to use that new drug from the 1962 amendment, you've got to have market authorization. You have to prove that there's substantial evidence that the thing works. Well, that is a watershed moment in drug regulation. It also established the IND process because what the IND is, the investigational new drug process, it's actually an exemption that before it becomes marketed, you can still use this drug in an investigational context. And it established that the Secretary of Health and Human Services, not the FDA, but the Secretary of Health and Human Services, to whom the FDA reports, okay, so remember FDA, CDC, NIH, they're all agencies that work for HHS, Department of Health and Human Services. So the Secretary can withdraw a new drug, suspend a new drug application approval. 1962 also established gave FDA enabling legislation for the establishment of GMP, or Good Manufacturing Practices, drug establishment regulation, so you get to license the actual factory, and requirement to prove efficacy of all new drugs. Okay, let's talk a little bit about in 1965, reviewing the period from moving forward. We had some problems with some drug abuse in the United States, and there were new powers given to FDA to regulate products to prevent, to try to control drug abuse as best as possible. 1966, there was the Child Protection Act, in which mandated that medicines had to be packaged in certain, I'm sorry, that was 1970. They had to be packaged so 1966 was the Child Protection Act, and the context of that act I will leave you to read in the book. But its powers were transferred in 1972 to the Consumer Product Safety Commission, as were the 1970 Act, which originally those powers were vested in the FDA, to require child-resistant packaging. So there was a recognition that there were way too many child poisonings. And if we had child-resistant packaging, which has its own problems because it becomes patient-resistant packaging as well in certain instances. 1968, animal drug amendments, drugs for feed. It's still a huge problem. Their antibiotic resistance, no doubt, has resulted in considerable measure from the fact that most of the antibiotics that are produced in this country go into feed animals. The vast majority, and I mean vast, like well in excess of 90% of all antibiotics, and we are losing the potency of those medications to treat human disease. Okay, so 1968, the Radiation Control for Health. For products that emit radiation, it was recognized that the emission of radiation has important human consequences, and that we need a human health agency to regulate those. And so that's the reason why the three big well, there are many centers at FDA. FDAs are organized by centers, and you'll hear that later on. The Center for CDRH, the Center for Devices and Radiologic Health. That's the reason it has those initials. And 1972 was the Drug Listing Act, which established a more formalized system by which drugs can be regularly recorded on lists held by the government. 1976, the Medical Devices Amendments included the definition of a medical device, and you can look at it on page 41. I'm not going to take the time since I'm running low on time right now. It defined a pre-amendment, post-amendment devices. So 1976 was an important cut date in when you need to go through certain approval processes. If that device had existed prior to 1976, there are different rules, and it also established three classes, and we'll get more into that when we talk about device regulation. Class 3 requires a pre-market approval. Class 1 is regulated by general controls, and Class 2 is somewhere in between, in the middle. They may require performance standards, but it gave FDA broad powers on medical devices that it didn't have. 1983 was special to me, the Orphan Drug Act that I was responsible for implementing. We could talk about that for an hour or two, but we don't have time. I commend you to Dr. Ian Phillips, who's teaching a fair bit on that, and we can. But basically, the upshot is there was a recognition that people with rare diseases weren't getting therapies because there wasn't good economics. They created a new incentive of market exclusivity for people who produce drugs who first get orphan status designation and then produce drugs that treat rare diseases. And it's been incredibly successful, to tell you the truth. It's almost 400 products have gone to full marketing approval because of that market exclusivity incentive that has moved things forward. 1984, the Drug Price Competition and Patient Term Restoration Act, also called the Hatch-Waxman Act. FDA is required now to approve generic drugs. This is the introduction of the concept of generic drugs, because drugs were costing too much. They said, let's make some of these things cheap. And the way we'll make them cheap is we'll allow an applicant for a new drug to utilize the clinical data for its application from the antecedent drug, if it can be shown to be, quote, bioequivalent. So if you can show that it's bioequivalent, we'll talk a little bit more about generic drugs coming, but you can actually utilize the clinical data that you yourself did not generate. And as a way to throw a bone to the people who actually were the founder drugs, the initiator drugs, they extended the patent lives on drugs, recognizing that it takes just so long to get a drug developed that they needed to be given something. So it was a balance between the two. 1988, generics came in for animals. 1987, the Prescription Drug Marketing Act prohibited the sale or purchase of drugs in a sort of under gray market area. There were substantial penalties, and whistleblowers were given up to $125,000 for blowing the whistle on things. 1990, the Safe Medical Devices Act defined the PMA process, and we'll talk a little bit. That's sort of the main process for pre-market approval. That's what PMA stands for medical devices. 1992, the Generic Drug Enforcement Act. There was a scandal in the FDA. It's a great story. I hope I get to talk to you about it in the discussion. Somebody asked me the question, and I'll tell you a fun story about that act and how it all came to pass. 1992 was the PDUFA, the Prescription Drug Users Fee Act. Okay, so things were stuck, constipated at the FDA. Applications were not making their way through. There was a backlog. And somebody said, well, what we need to do is there weren't enough people to review the stuff. The workload was just enormous. The biotech industry was expanding, and the U.S. Treasury didn't have the money to pay for it. So it said, let's do this. We will bring in, we'll set a fee. If you want the FDA to review your marketing application, you got to pay us $1 million. Right now it's $1.8 million, actually. And with that money, we will hire reviewers. So this is the way that the FDA was able to sustain itself and to grow in the numbers in its review capacity. It also included, in later iterations, a broader, more specified timelines in terms of how fast the FDA had to turn things around at various stages in the review process. 1990, the Nutrition Labeling and Education Act. If you have ever bought some food in this country, you will see that there is a very standardized nutrition label on that thing, and that's what that bill did in 1990. 1994, there's a Dietary Supplements Act. In large measure, this was an act to define what shouldn't be regulated as either drugs or as tightly as foods, because dietary supplements, vitamins and things like that, really started to take off in this country and had certain adherents who wanted to prevent the power of government from exerting too much control over them. So they defined this new concept of dietary supplements and excluded them from regulations for other products. 1997 was the Food, Drug, and Administration Modernization Act. Broadly overhauled, did a lot of changes to a lot of different areas. I can't go into them all. I commend you to the paper 1992 Act, the Best Pharmaceuticals for Children Act. Gave a new incentive of 6 months of exclusivity, market exclusivity, if you will, in fact, do some studies on children, because it was recognized that we were extrapolating from use in adults to use in children, and things had never been proven in children. 2002 was the Bioterrorism Act. We were reeling from 2001, the September 11th issues, and it provided for accelerated approval for medical countermeasures, new authorities with foods. In 2002, there was also the Medical Device Users Fee and Modernization Act. That was similar to PDUFA on the drug side. Now we had fees for submitting your device for review. 2003, the Pediatric Research Equity Act, or PREA, established that FDA can require you to do studies in children if it's necessary for the public health. 2004 was the Minor Use, Minor Species Animal Health Act. Again, this was like the Orphan Drug Act in humans as applied to veterinary products. 2004 also the Food Allergen Acts. There's a real problem with peanut allergy in this country, and it required that you had to actually, not only peanuts, but several other substances that are major allergens had to be put on the label. 2004 Anabolic Steroid Control Act. Again, we have problems with teenagers taking anabolic steroid, not just teenagers, but a lot of people, in order to buff up their muscle mass, and this is a major public health problem. 2004 Project BioShield allowed FDA to permit some interim use of new devices and drugs in response to concerns about bioterrorism. 2005, contact lenses become medical devices. 2005 also had some stem cell regulation, and 2007, the FDAA I've already brought up. Well, listen, we have blown through a lot of material in a very short period of time. I really recommend you look at the book. I said read the book, read the book. It's real important. And we will be having a class discussion tonight. I look forward to this. This is great to have you all, and we move on to our next lecture shortly. Again, thank you so very much. Talk to you later. Bye-bye.